When the Bribery Act 2010 was introduced, a huge profile was given to its impact. The impact it was going to have on corporates, the prosecutions, the need to have procedures, compliance officers and so on. Several years on, we're reviewing the impact of the Bribery Act to see, does it really matter? Does it make an impact? Do you need to be worried about it? How many prosecutions have there been? These are the questions that I'm going to be discussing with our expert, Helen Davenport, on the Bribery Act 2010 update. Helen, we've had the Bribery Act for a couple of years now. Have there been any convictions?
Well, there have been convictions. The Director of Public Prosecutions has convicted 3 individuals for bribery-related offences. However, the conviction of the court clerk who accepted £500 for not recording motoring offences, the conviction of the would-be taxi driver who paid £300 for a pass on his driving licence test, and the conviction of the student who offered £5,000 and pulled out an imitation firearm trying to achieve a pass mark on his dissertation, have hardly dispelled the thoughts of those who think that the Act was perhaps overhyped.
Why have there been so few prosecutions to date?
I think there's 3 main reasons for that. The first is we have seen that there are funding and bandwidth challenges within the SFO. The SFO have recently had to get additional funding from the UK government to pursue their aims and objectives. But in any case, the second reason is self-policing, or the policing, I should say, of the Act is very difficult because it relies on whistleblowing and or self-reporting for the matters to be able to come to the attention of the SFO in the first place. The third issue is that in any case, the time it takes for these issues to come to the attention of the SFO, for them to be investigated and then for prosecution to follow if appropriate, takes a long time. We know that the SFO are saying they're still investigating matters that took place under the old law, so predating the Bribery Act 2010. So perhaps we'll have to wait some time to perhaps see a conviction under the new rules.
What do you think is next in potential developments under the Bribery Act?
There are some developments that either are certainly are going to happen or that might be coming up to the tracks. The first is sentencing guidelines for corporate offenders. Up until these guidelines, there was no indication of the level of fines that a corporate might receive if it was convicted of an offence, but guidelines have now been published and they'll apply to all sentences from the 1st of October 2014. They confirm that the level of fine an organisation might face will be made up a number of factors, but in particular the harm, so the monies obtained or avoided by the bribe, and also the culpability of the organisation in question. And if an organisation is found to be highly culpable, then the fine could be as much as 400% of the monies obtained or avoided, so that certainly could be a chunky fine. There are some other developments that might be in the pipeline, but by no means certain at this stage. The first is that there is consideration of the case for incentivising whistleblowing, possibly financially, and that's following the Home Office publishing their Serious and Organised Crime strategy in October 2013. The rationale behind that would be to get these issues more out in the open and enable the SFO to prosecute. So that's one possible development. The second is the possibility that the director of the SFO has suggested that it might be a good idea if the corporate offence was extended not just to cover bribery, but also other offences of dishonesty and fraud. And the rationale behind that is to make it much easier to prosecute dishonest and fraudulent corporates. So I think those possible developments illustrate an increasing trend towards economic crime not being tolerated.
What are deferred prosecution agreements?
Deferred prosecution agreements were introduced by Section 17 of the Crime and Courts Act 2013, and they are available to prosecutors now with effect from the 24th of February 2014, so quite recently. In essence, what they are is that the prosecutor will still commence criminal proceedings against an organisation that it considers has committed a bribery offence, but that those proceedings can be deferred in return for the organisation signing up to an agreement, a deferred prosecution agreement, which will set out various conditions that the organisation needs to commit and adhere to, such as the payment of fines, compensation, or other conditions around cooperation.
Are they public or private?
They certainly shouldn't be viewed as a means to a confidential outcome. The final hearing of any deferred prosecution agreement will be in open court, so it's very much a public thing.
When is the SFO likely to prosecute?
There's a number of codes and guidance which the SFO will be following whether to decide whether to prosecute or not. But in particular, they'll be following the Code for Crown Prosecutions, which sets out a two-stage test. Firstly, is there enough evidence to justify achieve a conviction? And secondly, is it in the public interest to prosecute?
When can deferred prosecution agreements be used, and how likely is it that an organisation can enter into one?
Well, deferred prosecution agreements are for use in fraud, bribery and other economic crimes. They're only available for corporates, so it's not something that an individual can enter into. However, a critical factor is that discretion over whether an organisation can enter into a deferred prosecution agreement or not very much rests with the SFO, and it has the discretion whether to agree one.
Can any comfort be taken from the lack of corporate prosecutions under the Act?
In our view, it's far too early to say. There are reasons that why perhaps we haven't seen any corporate prosecutions to date, and if anything, in our view, the prospects of a prosecution are going to become greater and not less.
So, in summary, what should an in-house lawyer be doing about the Bribery Act?
Well, we think you certainly shouldn't be taking any comfort from the lack of corporate prosecutions to date. If anything, the risks of prosecution are going to become greater and not less. So your organisation needs to take steps to reduce risk and put in place the adequate procedures that may provide a defence to the corporate offence under the Act. The first step in putting in place adequate procedures must be to undertake a risk assessment of the risks faced by your organisation. If you go straight to putting in place procedures without thinking about why they're intended to address the risks, it's going to be much harder to demonstrate that those are considered to be adequate. Our 3 top tips for putting in place adequate procedures are as follows. The first is adopt standard with caution. That's not to say that there isn't a role for standard tools, methodologies and documents within an overall package of adequate procedures, but the guidance itself says that adequate procedures must be proportionate. So clearly you don't need to put in place more than possibly you need to, but if you simply adopt standard without again thinking about the risks that your organisation faces, it's going to be much harder to justify those as adequate. The second is make sure you follow those procedures, monitor and review them. We've seen examples of organisations publishing their anti-bribery policies on their website, which is obviously a very positive step and shows their commitment to anti-bribery, but it can become something of an own goal if that includes a last review date, and that's been 2 or 3 years ago, so it therefore suggests that you've perhaps taken the eye off the ball slightly in terms of anti-bribery. Also, it's very important that organisations review their procedures in the context of any risks or changes in the risks of their business and then update the procedures in light of those. The third is that of behavioural change. In our view, we're seeing organisations that are changing their behaviours in response to the Act, and if your organisation isn't, then it's potentially making you an easier target for a prosecution.